A Pennsylvania fire chief is in hot water, and not for battling flames, but for what police say he did to his own child. Brian Salt, the man trusted to put out fires, is now accused of sparking a tragedy inside of his own home. He was arrested and suspended indefinitely after allegedly admitting to intentionally dropping his 3-month-old baby, a fall that left her with a fractured skull. Salt is now facing serious charges, including aggravated assault and endangering the welfare of a child. But how did this all unfold? I'll walk you through the details. For Law and Crime News, I'm Kennedi Walker. Falls Township Fire Chief Brian Salt went from saving lives to reportedly nearly taking one, his own daughter's. According to a criminal complaint obtained by Law and Crime, Salt allegedly admitted to intentionally letting his 3-month-old baby slip from his arms, causing her to hit her head on the ground. On March 12th, Falls Township Police responded to Children's Hospital of Philadelphia after doctors reported a baby with a skull fracture. A detective met with the attending physician who stated the baby's injuries were caused by, quote, substantial force. The physician also noted bruising on her right leg and blood in her eye. Police interviewed both parents. According to the criminal complaint, the baby's mother told investigators she had gone to work on March 11th, leaving her daughter, identified in the complaint as AS, in Brian's care. Both parents described the child as, quote, fussy, and said she suffered from colic. Salt told police the 3-month-old wouldn't stop crying, so he took her to his in-laws. At first, Brian Salt reportedly told police that it was at his in-laws' home where he first noticed a large unexplained bump on the back of his daughter's head. The document states he called the pediatrician, who instructed him to take the baby to the hospital. That's when doctors discovered a skull fracture. But as investigators dug deeper, Salt's story began to crumble. A little more than a week later, police interviewed both parents separately about the incident. And that's when, according to authorities, Salt confessed. Salt allegedly told police that after his wife left for work, the baby became fussy and inconsolable. He tried to move her to her swing, but she kept crying. Then, according to court documents, Salt admitted that when she wouldn't stop, he pulled her from the swing and, quote, lost her. When investigators pressed him on what that meant, Salt allegedly clarified, saying that he intentionally let her fall to the ground and, quote, lost control. He told police he immediately knew he caused an injury to her head, but instead of calling for help, he took her to his in-laws' house, claiming he had just discovered the injury and had no idea how it happened. Brian Salt was arrested, his bail set at $500,000. Falls Township Fire released this statement saying Salt has since been suspended indefinitely pending the outcome of the legal proceedings. And joining me to talk more about this is Pennsylvania attorney Matt Mangino. Matt, thank you for coming on today. Let's jump right in. Can you explain the specific charges the fire chief is facing and what they mean in legal terms?
Well, he's facing endangering the welfare of a child, aggravated assault, and simple assault. The most serious charge here is aggravated assault. Aggravated assault is a felony, and what the elements are is that you've caused or attempted to cause serious bodily injury. And here we have a skull fracture for a 3-month-old, and that's certainly serious bodily injury. The simple assault is kind of a fallback charge where it's causing bodily injury, not necessarily serious bodily injury. But the most serious charge that Brian Salt is facing is the aggravated assault.
And based on the charges of aggravated assault and child endangerment, what kind of penalties could Brian Salt face if convicted? How many years, if at all, is he looking at?
Well, yeah, I mean, he's looking at some serious time. The fact that this is a child, that the aggravated assault is a felony. If he were convicted of the aggravated assault, the statutory sentence is 7 years in prison. So this is a serious offense, and because it involves a child, that even heightens the seriousness of this.
Could the fire chief's position as a public official impact the charges or penalties?
Well, that's an interesting question, and a lot of times, someone who is a fire chief and an EMT, just like a police officer, they're held at times to a higher standard because they should know that their conduct is causing or has the potential to cause such serious harm. Now, here's an individual. Again, he's innocent until proven guilty, but here's an individual who tossed a 3-month old on the ground, uh, you know, causing a skull fracture. Now, a fire chief and an EMT, those are the kind of people we think of who are going into a home or into a dangerous situation to save a child or to save somebody else. And the other thing is, you would expect that they're trained to handle stress. What we know about this allegedly is that the baby was crying and he couldn't control the baby and he got frustrated and snatched the baby out of the carriage and threw the child onto the ground, or the infant onto the ground. You would expect that someone who serves in the capacity that he does would be able to handle a stressful situation that involved a crying baby. So yeah, there is, you expect something more from people who have this specific training.
But do you think that could work to his defense, though? What we're talking about his very stressful job. He's the fire chief. Do you think that his defense team could argue, because of all of the stress that he deals with at work, that that's maybe why he potentially reached an alleged breaking point?
Well, I'm sure that ultimately in this case, the defense is going to want to present mitigation. They're going to want to present evidence that doesn't, say he's not responsible, but that says because of these circumstances, he shouldn't be punished as harshly. Maybe he's had some really difficult recent days, or maybe he's had some really difficult alarms that he's responded to it, and has PTSD or something like that because of those things. That's something that would have to be examined in pretrial. Experts would have to be consulted to come forward and say, hey, because of these past situations that he's been in, this is what triggered his conduct on that day. Again, that doesn't diminish his responsibility for what he did, but it might mitigate the ultimate penalty.
And earlier, you touched on the fact that he is an EMT. Do you think that it could potentially work against him that after this alleged incident took place, instead of him immediately rendering aid or immediately bringing the baby to the hospital, he brought the baby to his in-laws' home, and just more time passed?
Well, right. I mean, this is an individual who is trained to help others who are in distress. Now, that's what he does. Um, and you know, you've allegedly thrown a 3-month old onto the ground. Um, you know, if he were responding to a 3-month old in distress laying on the ground, would he have said to the mother of that child, or whoever's the guardian of that child, hey, uh, where do your grandparents or your parents live? I'm going to take the 3-year-old over there first. No, that wouldn't happen. That by no means. I'm sure in his career he's never made that decision that he's going to take the child to someplace other than a hospital when he's responding to a call. Why would he treat his own child in the same way?
And speaking of the baby's injuries, in the complaint, they were described as being caused by, quote, substantial force. How does
Mhm.
medical evidence play a role in a case like this one?
Well, it'll play a significant role because you will need medical testimony to not only establish what the injuries are, but how these injuries could have occurred. Okay. So what happens in a lot of cases of child abuse, child shows up with a fractured skull at the hospital, and the parent says, "Oh well, he fell off the couch." Well, you're gonna, medical testimony will establish that falling off a couch onto a carpeted floor, or even a hardwood floor, or even a concrete floor, is not going to cause that extensive of a skull fracture. That there has to be a certain amount of force to cause an injury of this degree. And we know, based on at least the news reports, that he has admitted that he threw the child onto the floor. So yes, medical evidence is very important in establishing that this wasn't an accident. In fact, it was an intentional act.
Because of that, could prosecutors push for additional charges such as attempted homicide just based on the severity of the
Mhm.
baby's injuries?
Well, they've charged at this point, the charges that we've discussed, and I'm not sure of what the procedure is, in Bucks County, uh, in eastern Pennsylvania, but a serious charge like this may have already been reviewed by the district attorney's office before it was filed. Okay. And because of the nature of the defendant in this case, they may have reviewed it as well. So they've already made a decision. Now, if this was a decision that was purely made by the investigating police officer, yeah, the prosecutor could look at this and say, this is something more. This is, as you said, attempted murder. The thing about attempted murder is, in order to prove that, it's almost as though you have to prove a murder. And so it becomes a much more difficult, much more complex case. Uh, Here, maybe the police investigators, the district attorney have decided that this is the best route to go, and this is what we know we can prove beyond a reasonable doubt.
What legal defenses could Salt's attorney use to challenge these charges, do you think?
Well, I mean, again, I would look at, how this whole investigation unfolded. You know, he admit to the hospital that he threw the child onto the floor? Did he admit it to the police? There's at times ways that you can attack that statement as being unreasonable in the manner in which it was taken. Was he Mirandized? Was he in custody at the time? Did he voluntarily give this information? Was he subjected to a custodial interrogation? All those things have to be assessed and evaluated to determine, maybe you can get that statement suppressed, because that's a pretty damning statement to admit that you threw the child on the ground and the child has a fractured skull. So, you know, I'm sure defense attorneys are going to explore all those different um, options. I think what their main effort probably is going to be in this case, especially if his confession stays in, is how do we minimize, how do we mitigate the potential penalties? Because that statement is going to be enough with the child's injuries and the fact that he took the child to the grandparents' house before he went to the hospital. It is going to weigh heavily against him in this case.
And yeah, I was just about to ask if his initial denial, because he initially said at the hospital allegedly that he didn't know how this happened, and
Mhm,
then allegedly later confessed. Could all of
mhm.
this just be used against him in court?
Well, yeah. I mean, by giving two different versions, all right, that first version where you deny everything is kind of like, in indicia of guilt. You did something wrong, so you're going to lie about it. If you didn't think you did anything wrong, you would just tell the police or the hospital exactly what happened. Here we have two different versions. That's not good as well in terms of trying to defend this case.
How does the court system typically handle cases where a parent harms their own child?
Mhm. Well, every court is different, but we know that not only judges and prosecutors, but the public generally looks down upon the abuse of children, whether it's physical abuse or some other sort of exploitation. You know, it's um, intolerable. Courts frown upon it more so than other types of offenses. Prosecutors do, and the public does as well.
Now, if Salt pleads guilty, what kind of sentencing could he be looking at compared to if he, potentially fights the charges in court?
Well, in Pennsylvania, we have what are called sentence guidelines. And so those guidelines take a lot of different factors into consideration. All right. So, number one, does he have a criminal record? And it's unlikely that he does if he was an EMT and a fire chief. Without having a criminal record, he's going to be on the low end, at least, of one portion of the sentence guidelines. The other thing that the courts look at is the gravity of the offense. How serious of a crime was this? And you know, aggravated aggravated assault against a child is a serious offense. So that offense gravity score is going to be high. And what will happen is there'll be a range of sentences in the guidelines. It'll say, well, based on his record and the seriousness of this offense, his sentence can be anywhere between 2 years and 4 years. Okay, that would be the minimum part of a sentence, which means he would go to prison for a minimum of 2 years, if convicted based on those guidelines. Now, those guidelines can be mitigated and aggravated as well, which means they can actually be higher because of the circumstances of the case. So judges are bound for the most part by sentence guidelines, and those sentence guidelines are also utilized by prosecutors to offer plea agreements and things like that.
Since the baby has been released from the hospital, does that lessen the severity of the charges in any way?
I don't believe that it does. Obviously, was a 3-month old with a fractured skull. Thank God the child survived that injury and has improved enough to go home, and those are all good things. But that in no way diminishes the seriousness of the offense.
Yeah, thank God it wasn't much, much worse. And we know his bail was set at $500,000. How is that amount determined in cases like this?
Well, bond decisions are based on a couple of factors in Pennsylvania, and there's a rule of criminal procedure that lays out the things that a court should consider when determining what bail should be. Um, the number one issue is flight. Are you going to show up? And that's what bond is intended to do, to make sure that people show up for future proceedings. The next thing is, are you a risk to society? And in this situation, is he really a risk to society? I mean, this is a situation where his own child made him frustrated and angry, and he harmed the child. So I don't know that he's a huge risk to the society. The question is he a risk to flee? He has ties to the community. $500,000 is a high bond, and bond is not supposed to be punitive. It's supposed to do those two things that I just mentioned: make sure somebody shows up and minimize risk. Um, the $500,000 bond, I think, is a reflection of the seriousness of the offense.
And Salt was suspended indefinitely from his fire chief position. Could he be permanently removed even before a trial?
Well, I would think that the fire department in the municipality, um, want to make sure that the criminal case plays its way out, and find out ultimately, what uh, the outcome is. I think as long as he remains suspended and is not actively serving as a fireman or an EMT, there's no danger to the community. uh, it's much easier to remove somebody after they've been convicted of a crime than to remove them while a case is pending.
And Salt's wife was reportedly at work when this all took place. Could his wife face any legal challenges, though, if authorities believe she failed to report signs of abuse or alleged abuse earlier?
Well, yeah, we're talking, hypothetically here. A parent who is aware of a pattern of abuse, who does not take any action to remove the child from that situation, could be also charged with endangering the welfare of a child. But if this is a single isolated incident in which, um, the parent who was not present, um, had no way of anticipating, um, then no, there must be no responsibility on part of that parent who wasn't home for supervision.
Great. Well, thank you so much for coming on today. We really, really appreciate you taking the time.
Yeah, well, thanks for having me. It was great.
WPBI reported the infant has been released from the hospital. For Law and Crime, I'm Kennedi Walker.